Martin Amaewhule-led Rivers State House of Assembly has overridden the assent of Governor Siminialayi Fubara on 3 bills earlier passed and transmitted to him for approval. The bills, which were presented to the governor a month ago, include the Rivers State Education Return of Schools Amendment Bill, the Rivers Electricity Market Bill, and the Rivers State Commissions of Inquiry Bill 2024. Lawmakers loyal to the Minister of the Federal Capital Territory, Nyesom Wike, at their 94th legislative sitting on Thursday, made the decision to override the governor's assent after he withheld approval. Commenting on the 3 bills which were represented by the Majority Leader, Major Jack, and debated by members, the Speaker, Martin Amaewhule, cited Section 100 of the Constitution of the Federal Republic of Nigeria, 1999. When the Speaker put the question to a vote, members unanimously voted in favor of overriding the governor's veto. Speaking on the decision of the House, Amaewhule criticized Fubara, accusing him of indolence and ineptitude. He stressed that the governor could not hold the state back, insisting that progress must be made. A statement issued by the Speaker's media aide, Martins Nwanchukwu, and sent to newsmen confirmed the unanimous vote to override the governor's assent. Further criticizing the governor, Amaewhule described Fubara as someone who sees himself as being above the Constitution, the judiciary, and other extant state laws. The Speaker reiterated that the House would continue to uphold the Constitution and democratic principles, adding that by virtue of Section 100 of the Constitution, the 3 laws are now in effect in Rivers State. Honorable, what are your thoughts on the story? Let's get your thoughts on the story first.
Okay. First of all, the issue that has to do with the presentation of the budget by the Rivers State House of Assembly. Obviously, it is a burning issue within the state. In fact, beyond the state, it's a burning issue because these are the issues. It's constitutional in nature. It is people-oriented. Right. And then, most especially, it is the issues that is calling for a lot of attention in the state today. In fact, to nail it more carefully, that's one of the problems that Rivers State government is facing today because of this lack of presentation of budget. The law is clear. The law is clear. Section 100, subsection 3, 4, 5 of the Constitution is clear. In fact, Section 100 says for anything to be made law, it has to be by bill, before the House of Assembly.
Right.
And then for such a bill to be made a law, such a bill must be passed by 2/3 members of the numbers of the House of Assembly members sitting as at the time the bill is being processed. Going further, subsection 4 of Section 100 gives power to the governor to assent to the bill when the bill is being passed, when the bill is already being passed by 2/3 majority for assent. Subsection 5 further now goes further to give power to the House of Assembly to pass or veto the powers of the governor where the bill is unwittingly being withheld or where assent is not being given by the governor of the state. From the information available to us, to me, these 3 bills have been transmitted to the governor for more than a month now. And I don't know, for any reason, maybe personal, maybe political or whatever, the governor have obviously refused to sign these bills.
Why do you think that is?
maybe political. Maybe he feels that if he signs the bill, he's giving power to the 27 lawmakers. But the question is this. Is there a court order? Or is there a judgment of the court that have temporarily, let us say temporarily, acknowledged or recognized the 27 members of the House of Assembly?
So why then is there a refusal?
Justice Baka's judgment that was made public on the 19th day of December 2024 made it clear that the act of presenting a budget to 4 members of the House is an aberration. And that since there is no other court that has set aside the judgment of the Federal High Court, Abuja, and then the court of the Federal High Court, and then this court, since there's no Supreme Court judgment that is, as I've overridden or set aside this judgment, then what it means is that the court have, by way of the law, given recognition to Martin Chike Amaewhule and the 26 lawmakers. That's what the judgment said. I think I'll read a part of the judgment for the general public to be aware. So, by that judgment, in fact, the truth of the matter is that the governor and the Rivers State government have gone ahead to challenge the outcome or the judgment of the Court of Appeal at the Supreme Court. If you have challenged that outcome of the judgment, it means you are not satisfied with the current position of the judgment. Right. And then we want the Superior Court to review what the lower court have done. But in the interim, the law is that you have to obey the judgment of the court as it is operational, during the period you have gone to challenge the matter at the Superior Court. So the governor...
But it's currently being challenged.
It's currently being challenged. What we are saying is the governor, His Excellency Siminialayi Fubara, is supposed or ought to, obey the decision of the Court of Appeal as far as this subject matter is concerned. If the Court of Appeal have told you that the 4 members or 3 members committee of friends have no power to entertain a budget that has to do with 31 constituencies of the state, and then you are going back to resubmit, present this budget before that same house, that same set of persons. Right. It means it's a contempt of court. You have failed to obey the orders of court, and it amounts to contempt of court. But it also shows that the governor does not have respect for the constitution that he swore to obey. That's the truth. And indirectly, one way or the other, this thing is affecting us. It's affecting the business in the state. In fact, it is within this period that I knew that Rivers State is standing on one leg. Unfortunately, Rivers State is standing on one leg because, I have seen that the life wire of this state, 70% of the blood wire of this state is embedded in politics. People can no longer come to the state to invest, foreigners, because they are afraid. I have personal friends who say, see, we wanted to bring in something, but I don't know the crisis in your state. I don't know if I set it up, how prosperous the thing will look like because of the political climate environment. And it is affecting the economic system of the state. And that's what the governor should know. If for nothing, I would have expected that he obeyed the judgment, at least for the time being. And then until anything is done otherwise. But for you to, in the face of the same judgment that has been given, that you have appealed against, to represent a budget before that same set of persons that the Court of Appeal have told you not to, it is an aberration.
If he has appealed to the Supreme Court, not agreeing with the judgment of the lower courts, why then do you think it's a good idea for him to, fall in or take the judgment of the lower court if he disagrees with that judgment, as it were?
Now, the law is this: if you file an appeal, it's expected that you need to also file what we call motion for stay of execution of the judgment.
Right.
As I speak to you, there is no stay of execution order by the Court of Appeal, or even before the Court of Appeal, or at the Supreme Court. There is no stay of execution of that judgment. So what it means is that the judgment is operational immediately the judgment is passed. And that is what the case of Obi against INEC is instructive as well. Once a judgment is given, it is operational, it goes. You must obey it until it is set aside. There are plethora of cases that the court have made clear mandate on, that once a judgment is given, no matter how dirty it is, the judgment must be obeyed. Section 287, subsection 2 and 3 of this Constitution of the Federal Republic of Nigeria provides that the judgment of the Court of Appeal or any federal court or court of competent jurisdiction recognized, by the Constitution of the Federal Republic of Nigeria must be obeyed or can be implemented, can be obeyed, implemented anywhere or throughout or anywhere or any part of this country. So if the court in Abuja has given that judgment, knowing that there is just one court of appeal, all the other divisions are for administrative conveniences or legal conveniences, but there is just one court of appeal. Okay, right. The Court of Appeal of Nigeria. The Court of Appeal of Nigeria. But for administrative conveniences, you have Abuja division, Port Harcourt division, as the case may be. So the governor should not feel, or River State government should not feel that because the judgment was given by a Court of Appeal in Abuja, it is the judgment that ought to be concerned with those that reside in Abuja. The judgment can be enforced anywhere, in any part of this country. Right. So that action of the governor choosing to cherry pick what he wants to obey, it is not only, it doesn't only tell doom on the democratic state of our polity. It also goes to annoy the system, the structure, that makes us, that holds the integrity of this, our existence politically. Right. You understand? Yeah. Yeah.
So, in overriding the governor, right, what does this indicate as regards to the power dynamics in the River State political landscape?
What it means is this. Section 100, subsection 5 of the Constitution makes it clear, and it gives power to the House of Assembly. Do you get it? It gives power to the House of Assembly. In fact, if I may ask, before the governor going before Okojombo and Sokari Goodboy, who are two persons that are manning the purported acclaimed House of Assembly for the governor, does that amount to two-third majority? Is there a majority? Can two persons conveniently legislate on issues that has to do with the general interest of 31 constituencies? This, I'm not talking about law now. Let us be morally just. Do you understand? Right. Can two persons conveniently legislate on a matter of public importance of such a nature, a budget that has to do with 31 constituencies of the state? Two persons. Who is the speaker? Who is the leader? Who is the members? Where are the 23rd? And I made it clear here. In Dapialong against Zari, 2008, the court has made it clear, that you cannot, on no account, should any member of a House of Assembly less than two-thirds proceed to do any legislative business without the required quorum. The Supreme Court has been angry about it because it is becoming an abuse, it is becoming a reckless activity of the legislature or the executive arm of the government using the particular number of legislatures to undo the processes of a system of a state. The Supreme Court have said it clearly. And I have made it clear here that if you go to if you read probably, if you take section 124 thereabout, you will see where this constitution, there also, you see how the constitution makes it clear that at no point should a particular House of Assembly be less than 20 persons.
Right, but there were pertinent circumstances in these situations, weren't there? Now, for the sake of our viewers, I want you to give us a breakdown of how this whole thing started, with the assembly.
Yeah, well, the governor, felt that I was insinuation that he felt that they wanted to remove him, impeach him from the office of the governor, and then all of a sudden, 2 or 3 persons in the house, saw that as an opportunity to rumor to the governor that they wanted to impeach him, and then after which the governor took side and said, oh, they wanted to impeach him, and then all of a sudden he just turned enmity with the majority house members, from which no form of consultations were made. The governor did not even call these persons to find out what was the true position. In fact, unfortunately, the governor has been acting on hearsay, and then, it has obviously gotten also where we are. But unfortunately, the truth is that the state is not moving forward. The state is not moving forward because there is no way a governor can succeed in a state without the contributions of the legislature. I say it clearly. And I get to be more angry sometimes when I hear people say, what about when the FCT minister was here as a governor? Did all these things happen? The question is, was there a division in the house when the FCT minister was a governor?
Now, there has been stories about defection.
Yeah.
How does that add up in the backstory, you just gave?
The thing is this. Section 109 of the Constitution makes provision for situation where when somebody defects, from his party to another party,
all right,
without any cogent, verifiable, and legal reason or defense. The truth of the matter is that there was no legitimate defection of the 27 lawmakers. There was no legitimate defection. There was no legitimate defection because the procedure for defection was not even followed. What happened was a political funfair. And
of them waving flags.
Exactly. You can, it's like you now, I say, oh, this is my wife, this is my wife. Yes, you may look like my wife, we may be wearing the same white. It looks like we are agreeing that we are together. But what the court want to know is, you say it's your wife. Where is the certificate of marriage? I hope you understand. The court goes beyond the funfair of looking at what the ordinary, everyday people will feel on the street. There's too much backlash emotion, tainted emotion that has taken over these matters. And it's unfortunate. Honestly, I'm so worried. I'm worried because emotion has taken over the whole street, and people don't get to want to dig deep into the issues that have culminated into this. There was no proper defection. As much as I saw that they waved flag,
right,
that was not a condition for defection. One, there must be transmitted a written notice to that effect to the ward chairman of the ward from where you operate as a member. Then number two, there must be a registration of your name in the register of membership of the ward where you are coming from.
Now,
of the new party.
Of the new party.
And then there must be deregistration of your name from the register of the party where you are living. In all these matters we are talking about, none of this evidence were exhibited before the court. So you want the court to now give you judgment because people wave flag. Is that what it should be? I'm more particular with, I'm a realist. As a lawyer, I'm a realist. I go deep down into the issue.
So the action of the wave of flags, what do you think it was about?
I say it's a political funfair.
Why do you think they saw the need to do that? What was the drive to do that?
Are they not politicians? If they wanted to use that to achieve something, how will I even know? Politicians are politicians. I can tell you the truth. I'm most concerned about the law. That's all.
Thank you so much. Also, how...
No, may I just quickly add?
No, go on.
Section 109, with all respect, is not self-executory. Section 109 is not self-executory. Because Nigeria operates the pure law school theory. I've said it clearly. Nigeria operates the pure law school theory. What does the pure law school theory say? It says that it is that thing that the court gives pronouncement on, that is law. The Constitution is a skeleton. It is until the court adds flesh to it that makes it more enforceable. Now, you say nobody should pass here, right? If the police knows, oh, this place is an easement or right of way, yeah, they go and block it unnecessarily because they feel they want to just block it for no reason. If for no reason. Not on the reasons of maybe if they want to make sure they check security and public safety and all that. That is excusable by virtue of Section 20 of the Police Act. Fine. But that if they block it without any justifiable reason, and then you find that your right under Section 46 is being breached, you will go to court and challenge it and say, my lord, please make an order. This section of the law. Why did the police not just say, oh, this person has a right? It is until the court makes an order. For instance, they impound your vehicle and you know that the impounding authorities have no power to do so. You can go to court to order amendment. So they compel them to release the vehicle or compel them to do what they are supposed to do because it is their duty to do it. Because we are in a society where until the law speaks hard, they will not listen. We have the body of laws.
Yes, we do.
We do have the body of laws. But until the law speaks hard, sometimes it's until some people go to prison before they can change. I can tell you, no matter how you preach the gospel to them, until they go to prison, serve their conviction and their sentence and their conviction, they will not change. If you like, preach all the verses in the Bible to them. That's what the law, that's what the Constitution is. It is a body of law waiting for the pronouncement of the court. So, Section 109, 1G is not self-executory with all respect. Because if it was self-executory, then it means that we will not be suffering ourselves going to court to file some matters because we want the court to make an order. What is self-executory is self-executory. Do you get it? All so, being that it is not self-executory, it needs the court to give an order on it for it to have flesh. That's what it means. And the same House of Assembly we are seeing, we have said it clearly before now, that people are not even thinking that a year Edison, as at when a year sat and then they took the first budget in 2024, as at when a year sat, a year was already suspended legitimately, which as at that time there was no challenge. He did not challenge the suspension from the House. He did not challenge the suspension. Meaning that once he was suspended, he had no business or no power to have to deal with any legislative issues that has to do with the interests of the House of Assembly. But he sat and took the budget he sat and took the budget on the grounds that there was an order from a court that had no jurisdiction. He sat and took the budget.
No.
Now, when he sat and took the budget, when he sat and took, the House didn't tell him, go and sit down and take the budget. The order of the court that he claimed didn't tell him to go and sit down and take the budget. But he sat and took the budget.
What did the other say?
The other was always saying, was always trying to declare the actions of the 27 lawmakers unlawful, having defected. You understand?
Right.
The order did not say, here Edison is the speaker. Go and sit down and take the, receive the budget from the governor. As at when all this thing was happening, here was already being suspended by the legitimate House of Assembly. And he didn't challenge it. That is, see, that is the error there. He did not challenge that suspension. So, and the suspension was ongoing when they took the appropriation bill for 2024, which was not supposed to be so. The suspension was ongoing. I don't know whether you understand.
Right.
The suspension as a member of the House, showing that as at that time, every activities that has to do with legislative business of the House within you and the House cannot go on. But he went for that on that name and took a budget, took the appropriation bill, take the presentation of the appropriation bill. Now, if the court has gone for that to say they did not have the right to do so, Justice Baka's judgment, I would have even preferred to take a bite of the judgment so that we will understand more what the law is saying. Look at what Justice Baka had to say. Justice Baka said, Haman Baka, JC, Justice of the Court of Appeal, delivering the judgment, he said it was worrisome. It was worrisome aspect of the appellant's conduct, which is Rivers State government. The appellant is the government of Rivers State,
right,
against Rivers State House of Assembly. Second defendant was, respondent was the Right Honorable Martin Chike Amaewhule-led, the Honorable Speaker. They even refer to him in the suit as the Honorable Speaker of the Rivers State House of Assembly. Okay, Central Bank, Zenith Bank PLC, Access Bank, Accountant General Federation, the Governor of Rivers State, Siminialayi Fubara, the Accountant General of Rivers State, the Rivers State Independent Electoral Commission, Honorable Justice S.C. Amadi, Chief Judge of Rivers State, and Honorable Justice Adolphus Nebeli. He said this appeal against the judgment of the Federal High Court, sitting in Abuja in suit number FHCABS 984-2024, between Rivers State government and the fellow defendant. The judge, why delivering judgment held, he said, it is worrisome. He said, it is worrisome. He said, worrisome aspect of the appellant's conduct in this matter. The worrisome aspect of the appellant's conduct in this matter is that he has not explained why he acted in this manner. The court cannot speculate in this regard. 27 constituencies by the appellant's conduct were denied representation when the appellant purportedly signed the appropriation bill into law. The business of Rivers State House of Assembly cannot be conducted in secret. This is unknown to law. The decision being a judgment of a court of coordinate jurisdiction is binding on the court to the extent of the fact which is pronounced as his decision, upon which it is on the validity and legality of the presentation of appropriation bill by the Governor of Rivers State to 4 members of Rivers State House of Assembly and affirm the judgment. The court went further by saying that the bill to Rivers State House of Assembly, led by the second respondent, herein as speaker, he said the Rivers State, to 4 members of the Rivers State House of Assembly, and affirm the judgment of the trial court therein, which had ordered the governor that he should present the appropriation bill to the Rivers State House of Assembly, led by the second respondent hearing the speaker. The judgment has pronounced on the issue of who on the issue of who is the Speaker of the Rivers State House of Assembly and the composition of the House of Assembly. It is binding on this court until the Supreme Court takes a final decision on the matter based on the appeal already lodged before it. It is wrong to say that since the particular issue is on appeal, it cannot be obeyed. This is the Court of Appeal talking. That since that judgment has not been stayed, I hope you understand.
Yeah.
Jurisdiction, therefore, is void ab initio. So the court has made it much more clear. The Court of Appeal, the Justice of the Court of Appeal has made it clear to the governor. You cannot say because you have gone on appeal, you cannot obey the judgment that is operational now. It is wrong. Excellency, it is wrong. So, what we expect the governor to do is obey the judgment, pending when there is any alternative.
Now, I want to ask you, why do you think that he has refused to obey this judgment?
I am just on belief that he feels that if he obeys the judgment or present the budget before the 27 lawmakers, I think that he feels that he will be giving them recognition. And it is not his, it shouldn't be his problem. That's the court ordering. He swore to uphold the letters of this constitution. The governor cannot be a judicial officer, be an executive officer, and a legislative officer at the same time. No, it cannot work. It is not so. This is not the see. This matter is not the issue of FCT minister, and that is where they are getting it wrong. They should leave the FCT minister out of it. And look at what does the Constitution say. What is the position of the law as at today? The Constitution says the law is saying, as we speak, these 27 lawmakers are the ones recognized by the law. Because that's what the court has stated. Why don't you deal with them until something else happens? Why do you have to go back to the same minority number of members of the same House of Assembly that the court have issued and ordered you not to go? Why are you indirectly creating a lot of conflict in the state? It is not wrong. It is very wrong, honestly. And the governor is committing very serious contempt of court. I'm telling you. And I think it is time for him to begin to, retrace his steps. The court gave him a leeway. It is as if when the Lord has said, as a sinner, go home and sin no more. As a good Christian, you should go home and sin no more.
But when you gave our viewers the background of the story, you said one of the issues that caused this problem to escalate to this point were rumors from some quarters as regards the governor, plans for the governor being impeached. Do you think that could also be a fear, as it were, on the part of the governor for not obeying this order by the court and challenging it still?
Impeachment, as I speak to you, is a rumor. I don't know whether they want to impeach the governor. I'm not aware. I'm not in any way. I'm not informed about this kind of thing.
Now, what I'm asking is, if there was that sort of rumor at all from the beginning of the
governor, as a leader, the governor needed to find out. He didn't need to act.
What do you mean he didn't need to act?
He didn't need to act by rumor or by hearsay. He needed to, as a governor, he needed to make findings properly. Yeah. That's what it means. I mean, see, politics, there's a lot of things in politics, for what I know. There are propagandas, there are lies, there are backstabbing, there are rumors. People can just do this to gain favor from you. People can set two persons set against each other just to make sure they gain favor from you. But as a leader, you don't have to dance to the gallery. You need to face reality. After all, these 27, all these members of the House of Assembly, including Okojombo and everybody, they went home and worked for him including my humble self that is here. We worked for him to make him governor. So why should it be that you want to unwittingly, for no reason, favor and unfavor certain number of people?
Right. So at this point, right, what steps do you think can be taken to resolve such high political disagreements to avoid bringing legislative and executive collaboration? At this point that this matter is seated.
The thing is, the governor should simply obey the orders of courts. Like I always tell my clients and those I've ordered to listen, I am not in the habit, or I will not be in the habit of advising my clients or people who are my associates not to obey court judgment. I hate it. Because once you begin to disobey court judgment, then you want to set the society ablaze. It was the same court that gave an order that no, River State allocation should not be withheld by the federal government, pay them. But the judgment did not tell Fubara, the governor of River State, to go into the Consolidated Revenue Fund and spend the money without appropriation. The judgment did not do so. So when they gave the judgment, people were happy, were fine, knowing that it will cause a lot of hardship on our people if the money is being withheld. Okay, but the judgment did not say, go and spend the money without appropriation. As I speak to you, whether they like it or not, the legitimate House of Assembly that is known to law today and in River State for any dealings whatsoever from any part of this country is Chikemati Amaewhule. It is visible to the blind, audible to the deaf. I expect the governor to rise up as a man and leave all this cheap political sentiment. Stand up as a man, address the issues, bring these people together. Handle the issues the way it's coming. You don't need to grandstand by standing on one leg, liaising with just one set of people. It's not going to help the issues. And as much as the governor is continuing to say that I will not recognize them as members of, when the court has said so, then are you saying you are bigger than the law? It's not a matter of sentiment. It's not ethnicity. It's not what I'm interested in. If tomorrow the Supreme Court says, because as part of when these matters were here before it went to Abuja, I think on 2-3 occasions I was part of the team of lawyers that that went to court here. So I follow the story. It is what we did practicably. So the governor will not say, oh, because the judgment is coming from Abuja, so the one that is coming from Port Harcourt or the one that the River State High Court will give is favorable. The one that the Abuja Court will give is not favorable. For Christ's sake, it's childish, with all respect. With all respect.
Right.
And if there's a right just about 4 or 3 days, about 2 weeks ago, that they got a judgment from the Court of Appeal, the High Court, that by Center for Association of Legislative Drafters Advocacy Professionals,
right,
that went to court to ask the court before Honorable Justice S.A. Piroku to Justice Apiroku to make an order on the governor to present the budget, okay, to obey the judgment of the Court of Appeal, okay, by asking the governor to present the budget before the 27 lawmakers. And the court set the judgment, dismissed the suit, and I think ordered 500,000 as punitive costs for bringing the suit. And the court went further to say that the the House have defected and all that. With all respect, it was amounted to dipping into a matter that was already concluded by a superior authority. That was what the judge did, and we expected that if the judge was going to decline jurisdiction, he ought to just decline jurisdiction and dismiss the matter. He needed not to go into the analysis of whether there was defection or no defection, because already the matter was before the Supreme Court as an appeal. So the lower court didn't have that power to review the matter on appeal.
Honorable, there's something I want to know, and I'm sure the viewers will want to know also. Why do we have this conflict of judgment? Why? You know, do you think this conflict of judgment has in a way deepened the situation more than it should have been?
Yeah, well, it is. Well, for me, I'm even surprised as a lawyer, and I'm not happy about what is happening, because the action of the government today in this state has thrown the judiciary into almost like a piece of mockery. Has thrown the judiciary into that kind of an image, like a piece of mockery, where even mechanics, bicycle repairers, taxi drivers, as the likes, will now be interpreting judgment and insulting the court, insulting lawyers that have spent days, hours, minutes to study, burn their candles, read, and then graduate, become a lawyer and all that, with all those hard trainings we had gone through. And then somebody that doesn't even understand the full meaning of his name will just wish and talk about the judiciary, wish it away with their left hand. It has cost me a lot of thinking. In fact, I am so worried. Why? It's because the government have refused to do what they are supposed to do. They have refused to obey See, the thing is this. Man should be able to be courageous to say, see, gentlemen, I know you are sympathizers of what is happening, but for the now, in order so that we don't fall more victim, can we obey the judgment? Now, what do you think the Supreme Court will do? Or what do you think the Supreme Court will say, having seen what the governor has done in the eye or on the face of a judgment of the Court of Appeal that is already in operation? What do you think? Do you think they will be happy? When the court has said, don't present, and you went further to present, how does it concern the FCT minister? How does it concern anybody? So if you present, are you doing the FCT minister? For crying out loud, if the governor cannot hold the 27 lawmakers, or even 10 out of the 27, I'm so sorry. I'm sorry that the state is getting so loose. Because as a governor, you should be able to have control.
Very well. Thank you so much.